It is now back in session. The Honorable Judge Simpson presiding. You may be seated. Back out. We're back on the record in the case of the People's State of Michigan versus Zachary Radcliffe. In this case, there are, in essence, competing motions regarding the defendant's bond. The defendant is asking that his bond be reduced, and the people are asking to the contrary that his bond be effective, well, not effectively, but denied in this case. The court rule is very clear and very specific in terms of when the court can deny bond to an individual. There's a statutory section which applies to it, as well as a court rule. Specifically with reference to the court rule, the court may deny bond to a defendant that is charged with criminal sexual conduct in the first degree, armed robbery, kidnapping with the intent to extort money or other valuable thing. Thereby, if the court finds proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person, or what one may say, a danger to the community. The court can take a number of factors into account, and I've given, I think, each side an opportunity to respond to the court's inquiry as to what was going to be important in terms of the court's deliberation. People have done, well, both parties have done an excellent job in laying the issues that the court needs to decide before the court. I would say that the people's rendition of the statements and stories, at least the minimal synopsis of the statements and stories of the alleged victims in the case, are indeed compelling to the court. And one of the first inquiries that the court had was, as the court sees the whole thing, what really is a grooming and predatory behavior as you see each of these incidents. The court does take into account also that the defendant's position within the church and access to the youth play a factor in that, as it does in cases where there are children involved and certain behaviors, threats, if you will, enticements, other things can come into play. What is also of note, and something that the prosecutor brought up and I think does bear noting, is that the defendant's bond initially, when the initial charges were filed and the arraignment was set at the $3 million, the current bond that it is set at, did not take into account the additional charges that came forth. So this is really, in essence, the first addressing of bond with the additional charges of the additional individuals. I say that because I want to make it very clear that any change by this court is not based upon it's based upon the motion, not based upon any abuse of discretion by the magistrate in terms of initially setting the $3 million bond. But the rules, in essence, well, defense counsel is correct in pointing out that one looks at an individual's release and their ability to have bond or to be in a position to post bond and not
This is where the
restrict.
hearing takes a serious turn. The judge isn't just looking at the charges themselves, he's examining patterns of behavior. In cases involving alleged grooming, courts often focus on access, authority, and opportunity. And from the judge's perspective, those pieces are starting to form a very troubling picture.
And not restrict their liberty, except under those limited circumstances. And then it is almost as if and it is up to the people at that point to show that the defendant should be incarcerated. In limited circumstances, that in some ways shifts the burden in looking at certain things shifts. For example, in a crime of treason, violent felony where the other predicates are met, and then in certain types of cases where there is an analysis of whether guilt is evident or where the presumption is great. Given what this court has heard and the motions that have been filed and the information that has been put before the court does find that there is a great presumption that the people have established a great presumption of the defendant's guilt in this case. I would also indicate that the court is taking into account that the behavior is indicated, at least is laid out here. And I don't know what would happen during the course of testimony, but what has been laid out shows, I don't even want to say classic predatory behavior, but it in a lot of ways is, where individuals are basically put into, these victims are placed into that position. Certain threats, either said or unsaid, are then placed upon these individuals, and then these individuals don't come forth. As the proffer indicated, that was put forth by the people. If that's true, and if the evidence, I should say, bears that out, one can see what the court is talking about with reference to an individual that is a young person who is forced to engage in sexual acts, who is then that next day has to see that person in, well, places, a church, and that person being in a position of power or authority. Been doing this a long time. That whole concept may seem like it's just something that just happened. Frankly, when one looks at it on the surface, that it's actually, if this is a circumstance where the two incidents, that's all that I had necessarily before me, occurred, that's not by accident. That is, that whole series of things is by design for a very good reason, because that stops this person from saying anything, doesn't say anything to the parents, doesn't say anything to the people in church, doesn't say anything because of where this happens. And the longer that goes, it becomes more difficult for the person to say so. In just listening to that, looking at what's been laid out by the people, the court, as indicated, does find that there is a great presumption of the defendant's guilt. It then shifts to show by a higher standard than normally would be applicable in a bond argument of basically a preponderance of evidence, but it shifts to a clear and convincing standard to show that the defendant is not likely to flee or does not present any danger. And that really does shift, in essence, to the defendant to show that, or at least put forth some evidence to the court where the court could conclude that. This court does not conclude by any stretch of the imagination that the defendant is not likely to flee. The court believes that the defendant is in a position of potentially facing life sentences. That also there is a circumstance, and it's a bit unclear, a bit murky, but where he knows that he is subject to at least an investigation and flees, or at least leaves the state. Oddly, where the parents, or those that most likely would know where they are, where he is, don't know. And he is there. Counsel may make a good point that when the very fact that if he were going to flee, that he comes back, under what circumstances and for whatever his reasons are of coming back, I don't know, and maybe that's to be told, but this court views that as something where clearly the defendant has connections in other states that he could flee to. I think that the laying out of the number of victims, not necessarily the numbers, but the number of the acts, make it more likely to this court that the defendant would flee or could flee to that. And the court does believe that he poses a flight risk. I also do believe, because I think it becomes a bit difficult when one is trying to address, does this person pose a danger to another person and or to the community? This court does believe that this defendant, given all of the circumstances that the court now has before, does pose a danger to the community. I've read all of the letters of support that the defendant does have, and people have good things to say about him. They have good things to say about his family. I make note of one thing that the prosecutor said, and it doesn't seem like it's much, but for this court it was much, where in talking with the Michigan State Police, she either blurts out or says that her son is leading a double life or a separate life. I don't blame her for saying that. I think it may have just been something that she said when she sees everything. And I think that that's true in this case. And so I also think that there isn't, given the magnitude of what the defendant is accused of in this case, that while the court has many tools at its disposal, the court doesn't have the, I don't think, proper tools that would be able to monitor and prevent the defendant from hurting other individuals or engaging in this behavior with other individuals. The only way the court would have to do anything along those lines is certainly to order that, but that doesn't mean that the defendant has to follow it. And then we don't know until somebody else's mental health and or physical health is damaged that it has occurred. And this court is not going to take that risk given the circumstances and what the court is looking at. Taking all of that into account and looking at everything, and now looking at this case with the number of charges, the number of alleged victims, the court does not believe that the $3 million bond, which was initially set, is an appropriate bond, and that under the circumstances, the court now has heard them and now knows the defendant's bond ought and should be denied. And so therefore, I will deny the defendant's motion to reduce bond. I will grant the people's motion to deny bond. Defendant's bond is denied. We are also set, go ahead.
Thank you.
We are also set for PCC. Are we ready to proceed to the next stage in this matter? Or we're
Judge, I was going to ask the court, will you give me will you do a written motion on that order that you just made?
You mean a written order?
Yes, sir.
I usually do not prepare a written order. If you'd like to prepare one, you may, and I look at it and sign it. But I mean, in terms of, there'll be a written order denying his bond. But
No, I understand. I just wanted your written findings in the order that you put on the record.
I'm going to let the record stand. If you want to draft an order, counsel,
Notice how the judge is explaining the psychology behind delayed reporting. Jurors and viewers often ask, why didn't someone speak up sooner? The court is laying out a theory prosecutors frequently present in abuse cases. Fear, authority, and repeated contact can create powerful barriers to disclosure. Whether that theory ultimately holds up at trial remains to be seen, but it's clearly influencing the court's analysis
Order.
here.
counsel, I will be more than happy to look at it and sign an order if it's appropriate.
Okay. So as far as the PCC goes, again, we just got their supplement report yesterday, number 12, where the last one we were doing on the 9th, that I had asked the prosecutor specifically if there were any more warrants out. There was not. Apparently there are. There's Snapchat warrant number 1 and 2. Based on that report that I just got yesterday, there's Beth's phone. I don't know what that is. And then she's got also on there that the MacBook Pro, the black MacBook, and another phone. Apparently they're still doing some forensic stuff on that. I'm also going to address some of the older stuff that we previously asked for, which she alluded to today, I think, which is the wired conversation between
What conversation?
wired. I've looked through my stuff. She can direct me to a time or date stamp or in a date for that particular conversation that was made between Priscilla and Mr. Radcliffe. I've looked through all my stuff.
You use the first name, Priscilla, being
Burke.
all right, go ahead. Oh, I got you. The X and him.
Yep. So there's apparently a conversation that was recorded that I don't have. I don't know if it's something that they've sent and it's in something else possibly, but I pretty much have gone through everything that has been sent and I have not seen that. And then we've also asked for the victim advocate's notes, which were done by Megan Calamita. Whether they're exculpatory or inculpatory, doesn't matter. We're entitled to them. And we have a right to those notes. If any of the victims made statements to the victim advocate, I would ask for those notes. And I previously asked for that information, Your Honor.
So what I have here is I have two things: the wired communication and victims advocates notes. Is what you're.
Those two things, but also, Your Honor, are we going to get Snapchat warrants? That I thought warrants were no longer in play, but again, we just got the sub report 12 yesterday, which says that these are outstanding. The Snapchat warrant 1 and 2. So I didn't think that there was any more warrants out there for material. If they are, that's fine. I just, I thought that we had already answered those questions.
Mr. Rose.
We would ask that a preliminary exam date be set. I believe that we'll need a separate date because of the number of witnesses and the length of time that it will take. So I would request that it not be set on a Tuesday with other exams because of the number of victims that are set, that will be testifying, I should say. The recording should have been sent, and I'll confirm with our discovery clerk if it went evidence.com or if it's something that counsel needs to pick up, but it is item 22, the recorded conversation between the defendant and one of the witnesses. So he should have that, and I'll double check. And
So you believe what's been referred to as the wired communication has been sent?
it should be. I don't know if it went on evidence.com. It's listed as item 22, so I have to check with Ms. Warnick because she sends everything out. I don't know if it was mailed on a DVD, but that should have already been
Gone
discovered.
to,
It
okay.
hasn't, it should, that's it. I don't believe, I don't have, and I don't believe that the victim advocate's notes are discoverable, so I would ask for some authority on that. I don't know how they would be relevant.
I don't
believe
know
that
how they would be discoverable either. Do you have anything on that?
I don't have, I think I may have something, Your Honor, that I can forward. I can file something as a supplement,
That's fine. I mean, on first blush, I almost look at it as though it would be getting an attorney's office personnel notes regarding conversations that they have with clients. And it would seem to me on first blush, I'll give you an opportunity to get something to me, that's going to be privileged information and that wouldn't be released. So subject to getting anything else, that's going to be my ruling, that those notes that with regard to victims from the victims advocates would be privileged communications because of their contact with the prosecutor's office and their work product, which may be part of the prosecutor's office. So that's the theory that I'm operating, but certainly counsel, feel free to file whatever is necessary. I was a bit confusing at the last hearing because I wasn't sure what warrants we were talking about. But I guess counsel has just received another report.
Supplement 12 is not a warrant. Supplement 12 is an interview with a witness about a conversation. Supplement 12, January 13th, 2025. A witness called to talk about disturbing comments that the defense father made. That's supplement 12. It has a journal, but it's barely a page long.
Oh, hold on.
That report was sent over.
Hold it, because I want to make sure we're talking about the same thing. Because when I listened to Mr. Thomas, it sounds to me like you were saying there was a warrant out. Information came back from that warrant.
Oh,
Created a report.
CCU forensic analysis of the defendant's devices. I don't know the time limit on that. If we don't have passcodes, we could.
No, I get that, but I want to make sure, folks, that in regard to number 12, that we're talking about the same thing. Because as I understand what Mr. Thomas is saying, and correct me if I'm wrong, Mr. Thomas, it seems to me he's saying that there was a warrant that was out, that warrant netted certain information that then was placed into some supplemental report, which was just produced.
right. I think it's at the end of 12. I looked at it briefly. I know it said something about the Snapchat warrants were out. It's I think toward the end.
So the supplement 12 is maybe 2 paragraphs. It's a witness that called to talk about some disturbing comments that the defendant's father made at 125. Status open, the case is open, pending the CCU's forensic analysis of the defendant's devices. There is something they're trying to pull off Beth's phone and search warrants for Snapchat 1 and 2. So those are outstanding things that the police department is waiting on, if you will.
Got it. Okay. So that's how I get to the Snapchat and the best. Okay. Now I think I understand.
The search warrants have been served and we're waiting on the return.
Waiting on the returns. Got it. Okay. Now I think I understand. So there was a report generated. At the end of that report, it just lists what else is out there that everybody's waiting on.
Correct.
And that's where the snap. Okay. Now I see where we are. So do we have any indication of when that might happen?
No.
I thought that's what you were going to say. Okay. So with that, counsel, I mean, I can set a preliminary exam date and what comes through, and I'll entertain whatever comes at that moment, but I don't know what's gonna, I mean, I have no idea what's gonna come of that. But what's your preference in terms of?
I mean, I'm fine, Judge. I think that, I mean, what I don't want is to get hit at the last second with a piece of evidence that we didn't get a chance to look at or to scrutinize, or, obviously you would understand that. I mean, you work on a strategy and, and then all of a sudden somebody produces something.
No, I got you. And I guess what I can do is, I can set a prelim date. I can then indicate that if something is there, then certainly I would allow you to make that argument where it would cause a problem for you, and I'll deal with it how I have to deal with it. But I think at this point we have to move this case along. So I'd like to do that. With the understanding that the other forensic, the electronic, the devices may not be available at the time of.
I mean, as your honor knows, these devices, it could take 2 years for the computer crime lab to get into them. So we can't adjourn, but we could be adjourned for another year, another 2 years. I just
Not doing it.
don't have the time.
I would just ask the court if, if it's not producing, they get it at the last minute. Either we're going to get continuance or not.
Right. I mean, well, counsel, just so that you understand how I work, I'm not going to let anybody. I expect counsel to do their due diligence in terms of any evidence that comes for us. So I don't expect somebody to lay on a piece of evidence that I haven't had an opportunity to do that. But I would not, I think counsel should be very clear. My expectation is that whatever information has to be given to each side will be given in ample enough time where the other side can do what they need to do. If they don't, if you run into that situation, I will always hear one's argument about why I can't proceed if something has just come to you. You haven't had a full-blown opportunity to do that. I'm not going to do anything that puts anybody at a disadvantage. So when would we like to do this?
Do you have certain days that apparently you do them on Tuesdays, right?
Well, yes, but that's rotating. But what Ms. Reiser indicates is that it's going to have to be a special day, so it's going to come off of my very skimpy docket I have to give.
Well, and Tuesday there are several other.
Yeah,
cases
yeah,
that-
it's not going to be a Tuesday.
Judge, I don't know if you'll do this, but can we do it on a Friday? Is that a possibility if we're gonna? Just asking though, only because.
No, I hear you. Okay, so just what my reluctance is I have housing dockets on Fridays, which are intense and very long. And when I put them over, that means the next following week is even longer. And are Mondays bad for you? Or
Just like any other lawyer, I mean, that's, I'm gonna have to make sure that I get everything cleared off my docket, on a Monday. But I'm not overly worried about it, Judge, but.
okay. Mondays work better for the court. I can tell you that. Ms. Reiser, what about Mondays regarding you?
I could find a Monday.
All right. So if we work with Mondays, why is this at 11?
This is a trial. That was the super.
You like the
Trials in the morning.
Do we have anything set?
February 24th?
Oh, February.
You think of something else?
He really shouldn't, but. Just, that's, yeah, okay. So I have available Mondays. I have February 24th, March 3rd, or the 10th, and whatever day we just clear out whatever else I have.
I am available February 24th.